2024 co-tenancies, just the rules. All right, our default tenancy is the tenancy in common. Is a default tenancy freely transferable? Yes, it is freely alienable, it's freely descendable, and it is freely divisible. In a tenancy in common, do all the tenants have the right to possess and enjoy the entire estate? Yes. What do they not have? A right of survivorship. General rule. A tenancy in common is the default tenancy. It is freely alienable, descendable, and divisible. And all co-tenants have the right to, that's right, possess and enjoy the entire estate. It has no right of survivorship. Scenario: Abe, Bob, and Charlie are tenants in common. If Charlie devises his interest to his two children and Charlie dies, what happens to the tenancy in common? That's right. Abe, Bob, and Charlie's heirs all have a co-tenancy. Moving on. Joint tenancy with right of survivorship is created with words of survivorship and, that's right, the 4 unities. Tip. Joint tenancy is created with words of survivorship and what? That's right, the 4 unities. Tip. The tenants must take title at the same time. They must take title with the same instrument. They must all have the same interest, and they all must have the same right to possession. Time, instrument, interest, possession. They have a right of survivorship. So if 2 people are married and one of them dies, joint tenancy will give that property to the surviving spouse. However, a joint tenancy can be held by more than 2 people. So if Abe, Bob, and Charlie own property as joint tenants with rights of survivorship, what happens if Charlie dies? The joint tenancy continues, and Abe and Bob now own the land. Does this mean that a joint tenancy cannot be severed? No. Can a joint tenancy be severed? Yes, it can. It can be severed in 2 ways. One party can convey their interest to another, or 2, one party can mortgage their interest. If a joint tenancy is severed, the part that is severed becomes a tenancy in common. So Abe, Bob, and Charlie all have property in joint tenancy, and Charlie conveys his interest to his 2 children or to a third party. Abe and Bob still own the property as joint tenants, but Charlie has conveyed his interest to a third party. Those third parties are tenants in common. Second way to sever a joint tenancy: one party mortgages their interest. Remember lien theory and title theory jurisdictions. A lien theory jurisdiction means that the mortgage holder, the lender, has only what type of interest in the property? That's right, a security interest. And therefore, in a lien theory jurisdiction, mortgaging one's interest in a joint tenancy does not sever the joint tenancy because the mortgage is merely considered a security interest. Contrast to a title theory jurisdiction. In a title theory jurisdiction, mortgaging one's interest will sever the joint tenancy. Why? Because that interest has been conveyed to the mortgage holder, and in a title theory jurisdiction, the mortgage holder takes title, and therefore they have the right of, that's right, possession on default. So we can sever a joint tenancy is not divisible, it is not inheritable. One person dies, the remaining joint tenants take the land. But if Charlie, party number 3, conveys his interest to another, that will sever the joint tenancy. Abe and Bob are still joint tenants, but the person to whom Charlie conveyed his interest, those people are tenants in common. Second way to sever a joint tenancy, mortgages their interest. Charlie mortgages his interest in a lien theory jurisdiction. Does this sever the joint tenancy? No. Why? Because the mortgage is considered merely a, that's right, security interest. However, if we are in a title theory jurisdiction, Charlie mortgages his interest. What result? That's right, joint tenancy, Charlie's joint tenancy is severed. The mortgage holder, the lender, has title and the right to possess. Tenancy by the entirety, joint tenancy for married couples only. We still need the 4, that's right, unities. Both partners hold an equal and undivided interest, and they have that right of, that's right, survivorship. Can tenancy by the entirety ever be severed? Absolutely. What happens if Annie and Bob are married and Bob dies? Annie takes the land. What happens if Annie and Bob divorce? Tenancy by the entirety is severed. What happens if Annie conveys her entire interest to Bob? Tenancy by the entirety is severed. Okay, so there are 4 ways then to sever a tenancy by the entirety. Death of one spouse, what happens? Surviving spouse takes the land. Divorce, what happens? Converts it to a tenancy in common, right? And probably it will be divided according to the property division rules in family law. 3, mutual agreement. Or 4, one spouse conveys their interest to the other spouse. Okay, so those are our 3 basic tenancies. Tenancy in common, joint tenancy with right of survivorship, 4 unities, tenancy by the entirety. Now, let's talk about partition. So we've talked about scenarios in which tenancies are severed, but tenancies can also be destroyed by partition in kind, meaning the physical property is divided, or by, that's right, sale. If a property is divided by sale, it has to be by agreement or, of course, by, that's right, action of the court. The court is going to force partition by sale only if it can't partition in kind. Okay, scenario. Abe, Bob, and Charlie each own 1/3 interest in mom and dad's farm. They would like a partition by agreement. Since they each own 1/3 of the land, if they want partition in kind, they would each take physically 1/3 of the land. They take in proportion to their interest. In this case, we have them owning equal shares, but the same is also true if Abe, Bob, and Charlie own unequal shares. It is divided in kind according to their, that's right, interest. 1/3, 60-40, whatever. And the court will force partition by sale only if partition in kind is impracticable, impossible, or it would result in substantial injury to one co-tenant. Impracticable, 2, impossible, or 3, substantial injury. So the court will force partition by sale only if partition in kind is I for, that's right, impracticable, I for, that's right, impossible, or result in S for substantial injury. When would partition in kind be impracticable or impossible? Probably if we're talking about a building. You cannot physically divide a house. When might it result in substantial injury to one co-tenant? Perhaps when that one co-tenant has been in exclusive possession and this is their only home. Okay, well, let's say that we have partition by sale. Anyway, each party is entitled to an A for, that's right, accounting for adjustments based on their expenses and improvements to the land. In partition by sale, each party is entitled to an A for accounting. They're entitled to an A for accounting. Okay, general rule. Partition destroys co-tenancies by physical division of the property, partition in kind, or by sale. If it's partitioned in kind, it is according to the, that's right, interest of each party. If it's partitioned by sale, it can be by agreement, but the court will only force partition by sale if we have I for impracticable, I for, that's right, impossible, or results in, that's right, substantial injury. And in any case, each party is entitled to an A for accounting. Moving on to the rights and obligation of co-tenants. First of all, let's discuss ouster. Ouster means one co-tenant refuses the other access. The ousted co-tenant has a remedy. What is it? Fair rental value from the time of the ouster. General rule. If one co-tenant ousts the other co-tenant has a remedy of fair rental value from the time of the ouster. Okay, let's talk rent. In each of these scenarios, the tenants have the right to possess and enjoy the entire property, right? Can they charge each other rent? No. But what if they own, Abe, Bob, and Charlie own a rental property? How do they split the profits and the rents? Proportionately. If they all own an equal interest, easy. If not, rents and profits are split, that's right, proportionately. What about expenses? Well, what are the expenses of owning a property? Taxes, mortgage, repairs. If Abe, Bob, and Charlie are all in possession. Guess how expenses are shared? That's right, proportionately. How about, so taxes, mortgage payments, repairs, any other expenses are shared proportionately if all co-tenants are in possession. What about if one of them is in possession and the other two are not? They can't charge rent, right? A co-tenant who has exclusive possession can't seek contribution from the tenants who are not in possession. Abe has exclusive possession of a property jointly owned by Abe, Bob, and Charlie. Abe can't charge Bob and Charlie rent, but he's in exclusive possession. He has a superior right to possess, and therefore he can't seek reimbursement or contribution from Bob and Charlie for his expenses, mortgage payments, taxes, etc. Unless the expenses exceed what? That's right, the fair market value of the property. Remember, what is Abe, Bob, and Charlie's interest? It's an ownership interest. If one of them is in exclusive possession, that party bears the burden of expenses, repairs, etc., unless they exceed the what? That's right, fair market value of the property. What about improvements? Under common law, improvements are not considered necessary. But remember, if something is partitioned by sale, what is each party entitled to? An accounting. So if we have a co-tenant who did make improvements, they are entitled to an accounting to determine what additional amount they might be owed. Okay, and those are the rights and obligations of co-tenants, partitions, and all types of tenancies.